Good afternoon, everyone. Thank you very much, Beth. And we always thank Beth, as we should, for putting all these programs together for us. We have a wonderful marketing department. Very proud of the work that they do, and hopefully you'll benefit from that today. So my partner, Aaron Connor, myself, Lou Pierro, we're here to talk about Medicaid trusts. And this is the second in a 5-part series that's going to cover a number of different aspects. We've broken it down into smaller bites so that you can have an opportunity to get educated on the particular aspect of Medicaid, or if you want to learn it all, to attend all 5 sessions, in which case we'll be covering nursing home care, the trusts today. We did basic Medicaid eligibility in session 1. And then in session 5, a topic that Aaron and I think is going to become much more important as budgets shrink and the need for quality long-term care expands, and that is advocacy and fair hearings. And we do a number of different types of litigation. Medicaid litigation is one that I've done throughout my career, argued cases all the way up to the New York State Court of Appeals. And when you have budget constraints and limited resources, what happens is those resources become challenged. And Aaron, we're already starting to see some of that.
Absolutely.
In the way that different agencies are treating things that were routine in Medicaid for a long period of time. And what drives this topic is the cost. We look at costs right here in the Capital District of New York, and we have offices in a number of locations, New York City, Long Island, more expensive down there, but even here, when we have clients, and we do every day, I'm just on the phone with one this morning, where mom's in a nursing home, she's going through rehab, they just terminated her Medicare services, and she's now on the hook at $15,000 per month. And when families write that first $15,000 check, Aaron, it's a bit of a handshaking experience, and then you're going to write them until your resources are gone. So the cost of care, and that applies equally to home care and nursing home care and any type of care in the long-term care arena, it's $180,000 per year. We have clients paying literally $250,000 per year for 24/7 home care. So today we're going to cover a little bit about the Medicaid numbers. We covered them in depth in session 1. So if you missed session 1 and you want to get a primer on the Medicaid numbers, go back to that. What's exempt, what's not exempt, and then what's our primary tool in our toolbox as attorneys to help protect assets and qualify for Medicaid. And then we're going to talk about a little bit of home care and an example on how the home care rules work today. And Aaron, I'm going to turn this over to you, but before I do, remember that if you're in the planning phase of this, if you're out in front of the game, you're in your 40s, 50s, maybe 60s, you want to look at long-term care insurance. You want to look at how you can plan to pay privately. What are the resources that you can marshal? How can you put your investments in place and have a fund that could finance your care? Long-term care insurance, we still believe in as a product, and it's something that you should look into, especially at the younger ages. But for most people, once you get to be in your 80s, 90s, hundreds, some 70s, some much younger, and you suffer a disabling condition or a chronic illness, and you need care, you don't have long-term care insurance. Only about 7% of eligible purchasers have purchased. You don't have an ability to use Medicare because Medicare doesn't pay for long-term care. It cuts off at acute care or skilled care for a limited time only. And so when we look at it and we don't have private insurance and we can't afford $180,000 a year, Aaron, there's only one place people can turn to get coverage.
And that is Medicaid, which is, as Lou said many times, the middle-class lifeline. But as budgets tighten and revenues have declined because of the COVID and the pandemic, we're seeing more of an assault on these. So it's important that you know how you might be able to still use these programs. So an individual in a home care case gets to keep essentially $900 a month, $904. If the couple if it's a married couple and they're both home, they get $1,320. The minimum monthly needs allowance applies when there's one spouse on Medicaid and one not. So usually we call that the well spouse. If the well spouse's income is below $32,590.50, money is shifted, income is shifted from the non-well spouse to the well spouse to get to that minimum monthly needs allowance.
And the spousal rules get a little bit more complicated than that. And there are ways to increase those allowances. You see footnote number 2. If the community spouse doesn't have $3259.50 of income, then they might get income allocated to them from the ill spouse, the Medicaid spouse, to get them up to that allowance number. But these two numbers here, the $23,400, which is for home care, for basic home care services, that's the total resource allowance for 2 people living at home. And this income allowance of $1,300 plus the $1320 is for 2 people living at home on Medicaid home care. So in order to get to these resource and income levels, you have to be basically destitute. And you have to get poor to get care. And that's just the way our system is built. And most people don't know that fundamental concept. For Medicaid purposes, you need to get poor to get care. And when you go to your local social service office, what they're going to tell you is you have to spend down all of your assets and all of your income to get to $15,904 a month. That's going to be the standard governmental answer to that question. But Aaron, there are some other things that are exempt over and above those basic levels.
Correct. So assets in the amount of $15,900, which increases a little bit every year. Maybe next year it'll be $16,000. It doesn't go up a lot. It's more than it is in a lot of states. That includes bank accounts, includes cash insurance or cash value on life insurance. So there are a lot of things that would possibly add up to the $15,900. A prepaid burial account is exempt as long as it's irrevocable. Income producing property, business assets, that can include rentals if they're in a limited liability company or other type of corporate form. Life insurance with a face value of less than $1,500. We don't see many of those anymore. That's the same value that's been since 1965. The big one is IRAs or other tax deferred retirement accounts in periodic payment status. Generally speaking, most people we see are of an age where they have to be in periodic payment status. That's not always true.
That's now age 72. Got pushed back under the Secure Act from 70 and a half to age 72. You take your required minimum distributions, but you can take it sooner.
You can, and we have in several cases had to, because someone was 65 or 68, needed had a long-term care event, needed services, so we needed to put them in periodic payment status to exempt them. And each individual can exempt 1 car, which whether they can drive or not is still an exempt asset.
And so how do you go about protecting? How do you know what these rules are? There are 2 steps that we recommend to all of our potential clients. And one is to get educated, and you're on this webinar, so that's the starting point. But you also have to gather up all of the necessary data. And for many people, they don't have this at their fingertips. So they're not quite sure what the cash value of their life insurance is, or who the beneficiaries on the retirement accounts are, things like that. So we have designed a questionnaire that is designed specifically to plug you into the Medicaid numbers and the Medicaid asset thresholds and exemptions, including disabled child exemptions and spousal exemptions. So we recommend that you start with that Medicaid questionnaire, which is on the resources page for today's webinar. So you can always find that questionnaire as well on our website, pierrolaw.com, but that's the place to start gathering up information, because you miss one piece of data and your application goes in a completely different direction. So for us to advise properly, getting that questionnaire done gives us a tremendous ability to just in one sitting, give you a very detailed answer on how you can be qualified for Medicaid. So we make that available to you, and we offer you a free consultation to sit down with that questionnaire and map out your own individual strategies. Aaron, the home gets some special protections.
It does. You can exempt it in a number of ways, but most of these are kind of late to the game ways. They're not the most optimal way to do things. If you have a disabled child, you can transfer assets to that disabled child without penalty. if you have a well spouse living in the house, sorry for the rhyme,
There's no
the house
mouse
is
in there
adjourned.
anywhere.
No, well, hopefully not. And but again, that's kind of a temporary solution. There's the intent to return home, which we have used several times when someone's in a nursing home, but we're trying to get them home. You file the intent to return home, and you can exempt or not get a lien accumulated against the house for months, which is can be a big tool. And when I say liens, what happens is if someone's receiving Medicaid services and they have a house, what happens is the Department of Social Services in the local county files what's called an open lien against the house that accumulates every month for services that are provided. These are usually big numbers and accumulate quickly. Then upon the death of the recipient, Medicaid will then go after the home when it passes through an estate. So there's a number of ways to avoid that, but that happens quite frequently.
So you may take the step of protecting the home with that intent to return home, or you may have someone exempt living there for a period of time. However, at the end of the day, you could end up losing the entire value of the home because it's in your estate and there's a absolute right to recover against your estate. Or if you're in a nursing home, they're going to put a lien on the home and be able to collect that lien at the point in time that you are deceased or if certain circumstances occur. So in order to protect the home, many people over time have done something called a life estate deed, where you would put your children's name on the deed. That's a gift, it's a transfer, it's a valuable transfer, and you would retain the right to live in the home. That's okay. But the way that we prefer to do it and the way that it's much more advantageous to each of you is to utilize a Medicaid Asset Protection Trust. And that's the topic that we're going to focus on for the rest of this afternoon's presentation. It holds the home, it holds your stocks, bonds, bank accounts, and it protects those assets. And it can be designed in such a way that you get significant tax advantages now and all the way to the point in time when your remaindermen inherit those assets from the trust. So you want to start us off, Aaron?
Sure. So a Medicaid Asset Protection Trust is a type of irrevocable trust. You appoint a trustee who manages assets for your benefit and ultimately your beneficiary's benefit. The trustee in a Medicaid Asset Protection Trust is not you or your spouse. It could be a child, it could be a friend, it could be a professional, really depends on your situation. I'd say in 90% of our cases, it's a child, but it doesn't have to be. The trustee is your fiduciary, meaning they have to act in your best interests. They're going to be in charge of what's in the trust. So that could be real property, it can be investments, it can be bank accounts, annuities, life insurance, could be a business. It's their duty to manage those assets for your benefit, to make sure that they're not losing value, that they're producing value when they should, and ultimately to go to who you wanted them to go to. It's also important to know that you have the ability to remove your trustee at any time if you have an issue, which is a big power. People think it's irrevocable trust. I've given up all the powers I could possibly have over it, but at least as we're currently situated, that's not true.
So again, a trust is a legal arrangement with three parties. You have the grantors, which if you have the assets and you want to set yourself up so that you're eligible for Medicaid without being poor, then you're the client. And you would transfer assets into this trust and have someone be your trustee to manage it on your behalf. They would manage it. They can pay you back the income. You don't have to take the income. It's discretionary. You can say that I want the income to go to my children and grandchildren, or you could take it, and that depends on your circumstances. So we design these very individualized so that it meets your particular goals and your family situation. And that's extremely important to fine-tune the trust from that perspective. And then the heirs ultimately are going to be the recipients of the remainder. You have the trust. The trust is there for your lifetime. It's legally protected. No one can take your assets. That's there for your benefit. And so that trust gets all of these assets, and you can have income. Principal is the stick in the mud, Aaron. And
yes,
we have to put a certain line, a wall up inside the trust that prohibits the trustee from doing certain things.
And one of those is giving principal directly back to you, because if you do that, The trust is essentially your alter ego, and you haven't really put separation enough where a DSS officer, Medicaid in general, is going to say that you set it outside of your state for the period necessary, and you don't have control over it. So that doesn't mean, however, that you can't ever get principal out. You just have to do it carefully. We draft these carefully. We set up what are called lifetime beneficiaries. Generally, they're kids. They don't have to be, again, they could be anybody. But that the trustee can pay money out to a lifetime beneficiary who can then use those funds for the grantor or the principal.
So remembering that in order to qualify for Medicaid, which is the only program that pays for long-term care other than private insurance, private long-term care insurance, which you would purchase and pay on your own. But if you don't have that, Medicare, which everyone gets at 65, does not pay. And in order to get Medicaid, you have to be poor. You have to get down to that $15,900 of total assets. If instead you create this trust in advance and you move your assets into the trust and they're managed there for your benefit, then at the point in time when you apply for Medicaid, this trust is not going to be counted as part of your assets. So that's why we call it an asset protection trust. We're moving these assets into the trust to protect them in the event that you need Medicaid to pay for that long-term care, that $180,000 a year that you would otherwise have to pay out of pocket. And the principal can come out to the kids, and very often we design it that way, or third parties, whoever you want as your beneficiaries. Once a principal distribution is made by your trustee to a child, there is no legal restriction on what that child does with the money. And that's the real key. If you don't trust them, don't put them on as that beneficiary. But if you trust your children or you trust these third parties to do the right thing for you, then they can get money, and it could then be used for any purpose, which could include you. So how do we make sure that you're protected? Aaron, it's important to remind our listeners that you have to do this out far enough in advance that you're outside of what's called a look-back period.
Correct.
And for nursing home care, that's
still 5 years. No momentum to change that. For home care, it's going to be 30 months. But as long as the COVID declaration, emergency declaration, continues to be enforced, we're seeing that date push back and push back. So right now, we don't have a date where we know that that's going to be the rule, but we do know that it's coming. So there's no reason to wait.
So common complaints that clients have is, well, this trust is irrevocable, or I'm not going to be my own trustee, or who's going to get this trust? Ultimately, I don't want to lose control. So we design into the trust certain security provisions. Number one, whoever you choose today as trustee, you can change at any time. So your fired can be aligned. And if that's the case, then you could appoint anyone that you choose to be the successor trustee. You're going to name beneficiaries. If people aren't doing the things that you want to do, then they can be removed as beneficiaries. And Aaron, one of those has a bigger impact, I think.
I think so. The trustee comes with some responsibility, but the beneficiaries are ultimately, if you reduce or cut out somebody entirely, that's the bigger stick, and that usually keeps people in line. So, and sometimes it's an event that you can't really have any control over. So you may want to just take them out altogether, and you do have that right.
And the last security bullet is very, very important. And that is, in New York State, as in many jurisdictions, we have a statute. I've used it many times. It's a State's Powers and Trust Law 7-1.9. And you can Google that, and you can get EPTL 7-1.9 in New York. What that says is, even though your trust is irrevocable, and even though you've given up some control over that trust, provided you can get the consent of the beneficiaries, you can amend or revoke the trust. And that's pretty good, Aaron, but it's even better when you consider the second bullet.
Meaning that you can take beneficiaries out?
Right. So if you have 3 kids and you've created this trust, and you say, listen, I want to take everything back. I don't like the way this is working. I want to get all my assets back into my own name. And you've named your 3 children as the beneficiaries. And one of them says, well, wait a minute. or they have a spouse chirping in their ear, you know, you've got a third of that. That's, you know, but don't let them take that back out of there. That's a third yours. What do? You remove that person, that child as the beneficiary, and the other two consent, and you break the trust. So you have the control over who the beneficiaries are, and with consent, you can break the trust. On the left side of this slide, you see the assets that we hold outside the Medicaid Asset Protection Trust. We don't want to bankrupt you entirely. We want to reduce your exposed assets to a reasonable level, but you're going to still have bank accounts, checking, savings, money markets. You're going to have enough money to make you comfortable that if you want to buy that new car, you want to take that trip, you don't have to go to the trust. You're going to have enough money in your name that you will be able to do the things that you want to do. And Aaron, this is the big ticket right here, because more and more and more of our clients, when they come into us, two-thirds of their net worth is in IRA, 401k, 457, 403b, in retirement plan assets.
Absolutely, and here's one of the benefits of living in New York is that is an exempt asset here. So in other states, you have to spend down your retirement account, or you have to spend a lot of it to become eligible.
Annuitize it,
Right.
which is taking it out on a periodic monthly basis. It becomes income. And we counsel a lot of clients that move. We've had a rash of people going to South Carolina, pretty popular state right now, must be the weather. So going down to South Carolina, the Medicaid laws are completely different. The good news is the Medicaid trust works in virtually every state except one, Minnesota. Don't go to Minnesota for retirement. But if you're going to the other 49, this trust is going to protect your assets and you're going to be able to qualify for Medicaid. However, not all states, and in fact, most states do not honor the exemption of the IRA 401k. So that's an issue that you're going to have to grapple with if you plan to move. If you're going to Florida, you're bypassing the Carolinas and Georgia. Florida is the same as New York. They exempt the 401k IRA, but something that you need to look at if you plan to retire to a different place. That's a huge question that you have to grapple with. And we are versant in most of the states that are retirement states at this point. We've dealt with most of them. So question comes up on the Roth. If it's a Roth IRA that doesn't have a required payout, you know, and Roth conversions right now are very popular because most people think income tax rates are going to go up. So they're doing their Roth conversions. And so Roth IRAs, so far, we've been able to put into the same type of periodic payment as traditional or taxable IRAs and get the same result where they are exempt as retirement accounts, provided you are taking your minimum distribution. So the advantages to a Medicaid Asset Protection Trust, Aaron, are many.
Very true. And even if you are so lucky that you never need Medicaid services, one of the big advantages is the assets in the trust pass outside of probate. So no court is necessary. Things can be done on your or whoever's schedule, the trustee's schedule, the beneficiary's schedule. You need to sell the house, you can sell it right away. You don't have to go to court. You don't have to wait. You don't have to wait through the creditor period. We do a lot of what I think of as downstream planning, meaning that you have the ability to set up trusts for other people as a sub-trust of this trust. We call those beneficiary control trusts. There could be a special needs trust in here. So there's really a lot of vehicles here that can be used. Again, you can hire and fire your trustee at any time. You can move the income around. And again, you do this early enough, you access the Medicaid services as planned, and you keep your assets protected in the trust.
So as we sometimes cynically say, well, you can either be poor to get Medicaid or you can look poor. Which would you rather do? And Medicaid Asset Protection Trust is an ability to do advanced planning, get out in front of that curve, and shelter assets. We're going to cover Medicaid Home Care in much more detail next week on Medicaid Monday. But let's just take a brief example. And here we have someone, this is a case that comes through our office almost every week. And it's someone hospitalized after a fall. They go to rehabilitation. No one ever gets clear answers. You can't see them right now because they're in rehab. And they have mild memory loss, disorientation, possible mini strokes. Just being in a hospital and then a nursing home makes you disoriented. They're still verbal. Daughter lives nearby and helps when she can. She's a good candidate for Medicaid Home Care. Most people don't know Medicaid has a very robust home care program in New York State. It is getting whittled away, but it's still there. And it's still very generous at helping people to be in their homes. The policy of New York State is to take care of people in the most independent setting possible. That's actually federal policy under the Olmstead Act, but it's something that we advocate for very, very strenuously to keep our clients out of facilities if possible and to get them back home. So here we have Social Security and a pension, total income of $2345. Remember the number, Aaron? 904. Well, we're over. Assets, $150,000 home, IRA of 75, checking and savings of 25, and a brokerage account of $250,000. So in this case, Rachel can create and fund her Medicaid Asset Protection Trust. We're going to put in the home, put in the brokerage account, and $9,100 of cash, total of $411,000 of assets. What asset did we not put into the trust? The IRA, and $15,900 of liquid assets. The IRA can sit in Rachel's own name. She can access it at any time. It's her asset, it's her money. She can take it down with required distributions or voluntary additional distributions. The 411 goes in the trust. For the income, and we'll talk more about this next week, we create something called the pooled income trust, and we send $1,441 to get her down to the 904 to that pooled income trust, which can then be used to pay bills. And Aaron, the results.
The result is she is now eligible for services. So we apply for the first of the month following all of these transfers. In a home care scenario, it takes some time to get services, but she is going to be deemed eligible with all of these transfers, and she's going to be well on her way to staying in her home for the rest of her life.
And that was my mom's wish. It's most of our clients' wish. My mom said, I'm not leaving this house other than feet first. And that was her goal. And a lot of people feel that way. Emotionally and physically, we don't want to be in a nursing home if we can be in our own home. And so Medicaid home care rules changing. We're not sure exactly what the implementation date is. Right now, the last official word was July 1, but COVID, if it keeps going, may push it back a little more. We're not sure. The point is, with the flexibility that can be built into a Medicaid Asset Protection Trust and the ability to get out in front and start the 5-year nursing home clock ticking and ultimately the 30-month home care clock ticking, unless you're privately insured or you have enough income to pay that $180,000 a year, this is something that should be considered as part of your estate planning. And so planning ahead or even in crisis, we use these trusts to shelter assets. The tax benefits are enormous for this trust. You keep your star exemption. You can sell your home, you get the capital gains exclusion. You get a step up in basis for the heirs on any appreciated assets. It's very, very powerful in terms of the asset protection and the tax neutral nature. We don't lose any tax advantages by creating this trust. Again, we're available to you for a free consultation. Email those questions in to info@pierrolaw.com, and we'd be happy to get back to you. Unfortunately, 30 minutes doesn't give us a lot of time for additional questions, but we will get back via email. So please feel free to email your questions. And remember to register for our upcoming presentations. And we also have our trust administration workshop. So if you really want to get more detail, a lot of clients come in and say, do I need a revocable or an irrevocable trust? Which is right for me? We have a workshop that's actually an hour and a half, so 12 to 1:30, that covers all of the tax and substantive aspects of trust administration and planning. It's an excellent workshop. We do it every quarter, and we would highly recommend it to you if you want to get down into the nuts and bolts and see how the engine really works inside of a trust. The 3 remaining Medicaid Mondays, the 15th, Medicaid Home Care. And again, we have a boatload of changes coming to Medicaid Home Care. We've done a number of webinars on that. We're going to cover it again next week on Monday. Nursing home Medicaid, how to qualify if someone does need a nursing home and what can you protect under those circumstances. And then what if you're denied? The advocacy and the fair hearings and the potential litigation. How do you make sure that your rights are being looked after and that you're getting everything that you're entitled to? So, Aaron, last word.
Get out there and do it early. There's no reason to wait. The rules are not going to get more favorable. So getting a trust in place, if you're at the age and you may be younger than you think you are, but you might be at the age.
Yeah.
And it's time to do it while the rules are still good.
Yeah, we have seen people younger and younger. We used to be people in their 80s, 70s, some 60s. Now we get clients coming in their 50s saying, I just want to get it done. There's wisdom to that because the trust laws have changed over time. The last time we had a major change to the trust rules was back in the 1980s. We've been living with this same law for a very long time, but we are already seeing agencies, county and state, look at the Medicaid rules in every facet and look at ways that they can get more money back and not pay the same level of benefits, have people use more of their own assets down to a poverty level, to make yourself poor to get care. And so this trust, as with all trusts, if you establish it today, it's going to be judged under the rules in effect today. And what they've done every time they've made a change to the Medicaid rules for trusts is they have grandfathered in anything that anyone has done up until that point. So with budget shortfalls and the deficit and debt, this is a good time to lock in your planning and get it done now. And as we say here at Pierro, Connor, and Strauss, Beth, get it done in 21. So with that, I want to thank you all for joining us today, and we hope you can join us for the rest of our webinars and check out our website. We have some past webinars on there, more detailed things, and if you want any tax information or tax guidance, we have webinars on the Secure Act and estate tax planning, all of that available at pierrolaw.com. Thanks. Have a great day.